Hi friends, I welcome you to the sixth class of Law of Torts, and the topic for today is strict and absolute liability. In the previous lectures, we have already seen what the vicarious liability is, which is a no-fault liability, and now today we'll learn about the strict liability, which is in Hindi it is called Kathor Dayitva, and the absolute liability, which is called Poorn Dayitva in Hindi. Now let's discuss the strict liability first, and then we'll see the differences between the two liabilities. Now, what is strict liability? The strict liability has been derived from a famous case of Rylance versus Fletcher. So in that case, the facts of that case are a person made a pond to collect water on his property, and the free contractor was appointed. Now during the construction, when the pond was ready, there was a leakage in the pond, and because of that leakage the water came out and it destroyed the other person's property. Now what will happen in this case? Whether the free contractor will be liable or the person will be liable. Now in that case, Justice Blackburn, he laid down a rule, and that rule is a famous Rylance and Fletcher rule. In that rule he said that if any person brings any dangerous or hazardous thing on his land for a non-natural use, and the nature of such thing is escaping, then that person will be strictly liable and not the free contractor. So if you see, he laid down the three principal components of strict liability. These are: first, the the equipment or the material of hazardous nature; second, the material is brought for non-natural use; and the third is that the nature of that material is escaping. So these 3 points are very important because these three collectively need to be satisfied to hold the owner liable under the strict liability. Otherwise the liability will go to the free contractor. So I'm repeating again that if he brings on his land any hazardous thing or hazardous material, one; second, for non-natural use; and third, if the nature of such thing is escaping, then in such case, for any mishap, the owner or the master will be liable under strict liability. Be mindful that strict liability is subject to the general defenses. Means, in the cases of strict liability, the owner can seek the general defenses which we have just seen in our previous class, which is class 5. So all those general defenses shall be applicable in the case of strict liability, but those exceptions or defenses will not be admissible for the case of absolute liability, which we will discuss now, and that is the prime difference between strict and absolute liability. So we have seen the case of strict liability, that there are three components need to be satisfied, and at the same time it is better to know that the general defenses that can only be applied until strict liability cases, they will not be admissible for the absolute liability case, which we will see after this. So apart from the three components of strict liability and the famous case from which it has came, Justice Blackburn, he decided in the case of Rylance versus Fletcher case, and that's why this liability is called this liability is based on Rylance versus Fletcher, and hence it is named on that name itself. So it is called Rylance versus Fletcher strict liability also. Now another case with strict liability. There is another case which is Reed versus Lyons and Company Limited. It is 1947 AC case. The facts of this case is that the plaintiff was a worker in a hazardous area, which was a factory, and it got blasted and there was an injury to him. So, but court held that there was no strict liability of the owner in this case, because although he was working in hazardous area, but it was not of escaping nature. It was a certified factory working in a hazardous area. There was the hazardous equipment, the hazardous material which was used over there, it was not of escaping nature. So that is why owner was not liable under strict liability, and hence the person could not receive any compensation for his injury. Another case is Sochaki versus Sass. It is 1947 AIR case. The fact of this case is there was a death due to fire in a house, as the chula, which is the traditional Indian cooker or a stove, we can say, which is based on natural products like wood and cow dung. So that chula was kept unextinguished, and after cooking food, the lady, she got burned and she died. So it was held that the master should be liable here, but actually it was not so. No compensation because the use here was natural. They were doing it as a natural case. It was not a specific or non-natural use, because that time in India, the majority of the population, they were using the chulas. So the use was considered natural and there was no compensation granted. Now another case was Noble versus Harrison, which is 1926 case. The facts are, the defendant planted poisonous trees in his house and one branch was outside his premises. This branch fell out and the person was injured. So here it was also said that the owner is not liable, because although the branch came outside, but the plant was planted as per the natural use. The use was not non-natural. So hence the owner was not liable. Another case is Ponting versus Knox. In that again a poisonous tree was planted and a trespasser animal, he came and ate that tree, part of that tree, and it died because of the poison. So again the owner was not held liable because it was in his premises and it was a natural use. So these are the all case laws, and you have seen the type of judgments given, and the emphasis again is on three things only: that to hold some owner under the strict liability, there must be the material which is to be used for a non-natural use, should be of escaping or escaping nature, and should be hazardous. If any of these conditions are not satisfied, the owner or master will not be held liable under strict liability. Now the another liability, which is absolute liability. This liability got originated in Indian jurisdiction in year 1985 based on a case which is MC Mehta versus Union of India. This is called absolute because there is no exception to it, and the general defenses of law of torts is not applicable in such cases which belongs to absolute liability. So the fact of the case is that in 1985 there was a company called Shriram Food and Fertilizers Industries, and they have a Delhi cotton mill. There was a leakage of oleum gas and an advocate died and lot many people injured and died. So MC Mehta, who's a public opinion oriented lawyer, he filed a PIL, which is a writ petition, and in that the judge laid down a rule. He said that if any person brings any hazardous industry, be mindful that the word used here is not hazardous material. The word is hazardous industry, means the complete industry. So he said that if any person brings hazardous industry on his land and it will create danger or has a nature to create danger to the life and property of the persons surrounding it, then there should be followed up as a absolute liability and not a strict liability, and in such case no defense or exception should be given to such person while determining his liability. So this was the decision of Justice Bhagwati in that case, and he said that I am deciding this in the interest of the social justice. So he also said a famous saying that let the master be liable as he has a strong pocket, and he is bringing the complete hazardous industry, so he should be the one who is principally responsible for any mishap. So based on this decision, the principle of absolute liability came into picture in Indian jurisdiction in year 1985. Now later in other cases, there is a famous case called 5-star hotel case, which is between Claus Mittal Bekaert versus East India Hotel in Calcutta in 1995. Now what happened in that case? The claimant, he got injured in a swimming pool and died after 13 years due to multiple injuries. Now whether he should be compensated? Yes, he was given compensation under absolute liability of the hotel, because this was in relation to the absolute liability concept. So this is all about absolute liability and strict liability. We have seen their differences and the origin of them, the cases on which they are based, they originated, and the typical differences. This is very important question with regard to your exam and interviews. So you must be aware about it. So that is all for this 6th class, and in the next class we will commence with the specific torts, and in the sequence we will take about the various specific torts where the intention is also in the picture, like negligence, nervous shock, nuisance, defamation, etc. So that we'll take up in the next classes. Till then, stay tuned. Bye.